Alright, this is Chris Chambers, Kristen Moore, and Carlos Urcha. We're going to be talking about the Engel versus Vitale case, which happened in 1962. Okay, so there was a New York state law which made all public schools begin the day off with the Pledge of Allegiance and a non-denominational prayer which made them recognize their dependence upon God. There were students who were allowed to not partake in this activity if they felt it was loathsome or obnoxious. A parent sued on behalf of his child, arguing that the law violated the Establishment Clause of the First Amendment as made applicable to the states through the Due Process Clause of the 14th Amendment. Alright, so then comes in play the First Amendment, which states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridging the freedom of speech or of the press or the right of people peaceably to assemble and to petition the government for redress of grievances. So the First Amendment's Establishment Clause prohibits the government from making any law specifically respecting an establishment of religion. This clause not only forbids the government from establishing an official religion, but also prohibits government actions that unduly favor one religion over another. This also prohibits the government from unduly referring religion over non-religion, or non-religion over religion. Okay, so the question being asked was, does the reading of a non-denominational prayer at the start of school day violate the Establishment of Religion clause of the First Amendment? And the answer came out to be yes, in a vote of 6-1 in a case which 2 justices did not participate. But the court said that schools cannot make it a mandatory chore for these kids to pray for the fact that this practice unconstitutionally entangles the state in religious activities and establishes religion. Okay, so the reasoning behind this was that the court said the First Amendment protects religious liberty in a way that it keeps the government from determining both how and when people should pray. The Establishment Clause was then found by a court which prohibited the government from involving itself in devotional religious exercises, meaning that the government has no right to choose what the kids are to do when regarding religion. Alright, so a significant person is Justice Hugo Black for the fact that he was saying that the court's decision was not anti-religious, but it rather sought to affirm the separation between church and state. And in the second quote by Justice Stewart, he is basically saying that the court did not apply a constitutional principle correctly. He argues that just because there are some kids who want to and say the prayer does not mean that an official religion is being set forth. But then he goes on saying that not giving the kids the opportunity to recite in this prayer is denying them the privilege and opportunity of sharing in the nation's spiritual heritage. Okay, so this Engel versus Vitale case was very important. It was a landmark United States Supreme Court case that ruled it is unconstitutional for state officials to compose an official school prayer and encourage its recitation in any public school. And this is our bibliography. Thank you.